My name is Steve Buck. I work at the law firm Quinn Johnston. I've been practicing for almost 27 years now. I started as a trial lawyer. I still do quite a bit of trial work, but I've, over the past 10 years or so, branched into more and more labor and employment work. And pretty much every year I speak at various presentations and seminars, and more I handle the employment law update, which I've come to call the latest efforts to improve your lives through governmental regulation. And I will say that in the past few years, it's actually been kind of a lean topic, and that's because, particularly in Illinois, we had a Republican governor and an Illinois-controlled Senate and House. They couldn't agree on anything, so you can consider it good news or bad news. I know which way I lean, but there wasn't a lot of employment law activity because nothing could be agreed on. Of course, we now have Governor Pritzker in the office of now, and we still have Democrat-controlled House and Senate, and there's already indications that it's going to become kind of fast and furious here as we move forward. Now that said, on the state side, the first thing I want to focus on is the federal law, the Fair Labor Standards Act, and what I'm calling the newest overtime rule. The reason I call it that is many of you may remember that back in 2016, a whole whopping 3 years ago, there was a lot of angst and concern among employers nationwide in having to comply with the new overtime rule issued by the Department of Labor under the Obama administration. It made significant changes to the minimum salary level for employees to remain as exempt from overtime rules. And that was the intended purpose of that. And we'll talk a little bit about what happened, but suffice it to say, the overtime rule is back in a slightly different form. The Trump administration's Department of Labor issued on March 7th a notice of proposed rulemaking to begin the process of basically finalizing their overtime rule, and that's in the comment period as we'll go through. Now, the Fair Labor Standards Act itself is the government propaganda says it provides a fair day's pay for a fair day's work. And basically, it's the standard that applies the federal minimum wage for those who are non-exempt, and it also requires that for non-exempt employees, they be paid overtime at the rate of 1.5 times their regular pay for all hours worked over 40 hours rather. Now, when we talk about exempt employees, there's two things, and this is key, and I want to touch on it before we talk about what the expected rule is and what employers will be facing. But to be an exempt employee, there's actually two parts of the test. Salary is only one component. The other part is you have to meet the primary duties test. So you have to be doing what the statute itself, the Fair Labor Standards Act, sets out as the exempt duties of an employee. And that's in the white collar exemptions is what they're referred to. So if you meet the salary and the duties test, you can be exempt from overtime. If you fail either of those, you're subject to the overtime rules. And I'm going to cover in very basic terms the primary duties test, and there's a lot of nuance and a lot of detail on this. More so I could speak a whole hour and put you all to sleep just on the duties test. But they're just somewhat complicated, but it does bear closer focus when you're analyzing what to do in light of what's going to be likely the new overtime rule, which we'll get to. But the primary duties, the other thing to keep in mind is it doesn't mean it's the majority of the duties. It doesn't mean it's the only duties. You can have employees doing exempt duties, non-exempt duties. So you look at what their primary purpose is or their focus is. If the primary duty is exempt, they can still be exempt even though they perform non-exempt duties. And there's a case out there with a Dollar General store manager who, because of the small area that they covered and the small nature of the store, the manager would unload the truck, stock the shelves, sweep the floors. Those are all non-exempt duties, but also had the management of the entire store, the scheduling, the policy making, all of that was exempt duties. Even though the manager spent about 30 to 40% of his time on exempt duties, he was still found to be exempt because that was his primary focus, not the non-exempt. So again, there's the intricacies to be aware of. Now, the basic categories are you have first the executive employee. And to be an executive employee and exempt, the duty has to be that you're managing the business or the enterprise or a recognized department or division of the enterprise. So if you're not managing the entire business, if you're head of research and development, head of manufacturing, head of sales, something like that. And the other part of that is you must directly supervise and control at least 2 full-time employees. And by that, you have to have the authority to hire, fire, discipline, all of those things. So if you meet those executive tests and the minimum salary, which we'll get to, you can be exempt under the executive standard. The next is administrative, and this is that your primary duty is non-manual work or non-manual labor, primarily in the management of the business operations, and you must exercise independent judgment and discretion on matters of significance. You know, it's all good lawyer speak, hard to understand what that means in practice, but the gist of it is, again, if your primary duty is managing some aspect of the business, setting policy, or even the authority by your judgment to deviate from said policy without having to seek permission, the ability to bind the company or the organization in contractual or other matters, you could fit the administrative category. There's also the professional category, and there's really two types of professional categories. And to have that, it's basically that your duties require an advanced level of specialized skill or knowledge, typically acquired through academic training or specialized instruction. And typically you'll find that with advanced degrees, law degrees, doctorates, master's degrees. I've dealt in the analysis of exempt versus non-exempt when you talk about social worker. And if the social worker doesn't have an advanced degree, oftentimes they'll be found to be non-exempt. But if they've got a master's and they're exercising independent judgment in their duties, they can be found to be exempt. There's also the creative professional exemption, and that is your duties involve imagination, invention, and creativity in a field of artistic or creative endeavors, which basically covers musicians, artists, painters, actors, producers, things of that nature. Also computer employees. But when you talk about computer employees, the mere fact that you're working on computers doesn't make you exempt. The computer techs who go out and fix things or troubleshoot are typically not found to be exempt. They're talking about the programmers and the designers of systems, the designers of the operating system itself, you know, the heads of the IT departments who are on call, things like that. And there's also the highly compensated employee, and that is they have to have a set salary that is a high salaried 6 figures, both under the current rule and will be under the proposed new rule. And you also have to have one of the duties of any of the other exemptions that we just talked about, and then you meet the highly compensated employee test. So where are we at right now? Well, we're still under the rule that was issued in 2004, and that set a minimum salary of $455 a week. Works out to $23,660 annually. So if you meet one of the duties and you're being paid on a salary basis, not hourly, at least $23,660 a year, you're an exempt employee. For highly compensated employees under the current rule, that again is back to 2004, you have to be earning at least $100,000 a year and have one of the other duties. And there's no process built in for updating this without going through the entire rulemaking process, which is why we're here talking about it again today. Now, under the Obama administration's proposed rule, they were making drastic changes. They were looking, and this was, at this point in 2016, everybody was figuring out what they were going to do. But the rule, it was set to go into effect the very end of November of 2016, was called to double the salary, the minimum salary threshold, actually just slightly more than double, to $913 a week, $47,476 annually. Highly compensated employees were being taken up to $134,000. They did build in what was a nice feature to allow up to 10% of that salary threshold to be met by non-discretionary bonuses, but they had to be non-discretionary. The employer could have a right to revoke those in the middle of the year or change, so that the employee with at least 10% of that salary accounted for bonuses met the minimum threshold. The other feature of the Obama administration's proposed rule was automatic updating every 3 years. So the salary would continue to increase. It was based on a formula by examining salary levels nationwide, that they would try to be at the 25th percentile of certain salary levels. The estimate was, had the Obama rule gone into effect in 2016, the first update would already be coming next year, and it would be taking the minimum to 51,000, a little over 51,000. So you ask, and if you recall, what happened? I got the slide right. What happened to the rule? Well, because of the drastic changes and the fact that the impact of the Obama proposed rule was going to instantly make over 4 million employees nationwide non-exempt who had previously been exempt, 21 states, because this does affect state workers as well, and several employer organizations filed suit in Texas federal court to challenge the rule and to have it found unlawful. Texas district court judge, in fact, issued a preliminary injunction finding that the rule itself violated the underlying basis of the Fair Labor Standards Act, and primarily because if you have absolutely nothing better to do, if you ever read the Fair Labor Standards Act, when they talk about exemptions, it's all about the duties test. It's all about what the employee's doing, and there's very little discussion of the salary test. And what the judge found is that they made the Department of Labor under the Obama administration made it basically a salary test. It did away with the duties, and people were going to be converted to non-exempt simply based on the salary level, and he found that that violated the principles of the written statute itself. The other thing he found was that there was no support in the law or in the statute for an automatic updating process. For the Department of Labor to issue a regulation on any issue, including overtime, they have to go through a rulemaking process. So they submit public input, they publish what their thoughts are, they get more and additional input, and then they finalize a rule that could be subject to scrutiny later. So this automatic notion that every 3 years we're going to increase it without a rulemaking process is found unlawful as well. So the judge issued an order that the rule would not be implemented or enforced on a nationwide basis. Of course, we had the presidential election in the beginning of November of 2016. So when the injunction was issued, President Obama was still in charge. President Trump had been elected, wasn't in office yet. The Obama administration filed an appeal of the Texas preliminary injunction to challenge it. But the briefs were not going to be due to be filed on the appeal until March 1 of 2017, after the Trump administration had taken office. And when the Trump administration took office, they immediately kicked the can down the road a couple of times, got delays in filing their briefs, finally filed them the end of June of 2017, and in doing so, affirmatively indicated that we're not going to advocate any longer for the $47,476 salary. We're going to do something different. So we're not challenging on that grounds. We just want the court to acknowledge that we have the right to set some minimum level of salary threshold, and that's the only issue that they were challenging. And shortly after they filed those briefs, they issued their own, and they began their own rulemaking process in July of 2017 by submitting a nationwide request for information to start to gather input and data so they could formulate their own overtime rule. About a month later, the Texas District Court judge issued his final ruling. It had been a preliminary ruling before, and basically followed along where the Trump administration was going, affirmed the ruling that the prior rule was unlawful because it focused too much on salary, not enough on duties, but recognized the authority of the Department of Labor to set a salary threshold, but it couldn't be the dominant feature of the rule. With that ruling, the Trump administration dismissed its appeal of the prior ruling, and that was granted by the Fifth Circuit Federal Court of Appeals, and that ended the Obama administration proposed rule. And so now, based upon the RFI that was issued in July of 2017 and the information gathering, on March 7th of this year, the Trump administration, its Department of Labor, issued its proposed rule. And its proposed rule is to take the salary threshold to $679 a week, or $35,308 annually. It's actually taking the highly compensated employee salary level even higher than what the Obama administration's department planned to do, to up to $147,414. It continues to use, or the ability to use non-discretionary bonuses to make up that salary threshold, but there are no automatic updates. It's recognized that that feature would likely be found unlawful. There's just a commitment, a promise, if you will, to review it periodically, and they're talking about every 4 years, but it would have to go through an independent rulemaking process before there would be any update. It's estimated that about 1.1 million workers, if their salary is not increased, would suddenly find themselves as non-exempt. based upon this new rule, and about 201,000 highly compensated employees would be in a similar situation. I will add that during the confirmation proceedings for the current Secretary of Labor, Alexander Acosta, he was asked about the prior administration's overtime rule and his thoughts on it because of the appeal that was going on at the time. And he indicated that he thought it was too drastic, it went too far, but he also indicated that he believed that the rule should be updated to at least reflect inflation based upon the salaries that were set in 2004. And in those hearings, he said he estimated it would be about 33,000, 34,000 is where he would see the department going. Of course, they hit pretty close to that mark. Now, what is the impact? Well, keep in mind, we're in the, fat fingers. The rule's not final yet. We're in the final comment process. You could all, if you want, go on to the Federal Department of Labor website. You can find a link when you go to the Wage and Hour Division, and you can comment on the rule and give your thoughts and opinions on it if you want. That comment period closes on May 21st, so a couple of weeks from now. Once that closes, then the administration could, based on its input, tweak the rule, put it out for public comment again, or they could finalize the rule. Most experts and analysts are predicting that we are going to get a final rule some point this year, probably mid to late summer, and it may very well just be exactly what's been put out for comment now, and it's anticipated that the new rule, once issued, or the new final rule, will be set to be implemented and go into effect in January 2020. So what does that mean? Well, that means if you want to maintain the exempt status of certain employees and they're making less than $35,308 a year, you need to raise their salaries. Same with the highly compensated employees, you need to increase their salaries as well. But keep in mind, this is not a requirement that you absolutely have to do that. You can make the decision if from a financial standpoint it doesn't make any sense, if you don't want to raise it, you're not required to. It's just the issue is whether the employee will continue to be exempt from overtime. At that point, if they're making below the salary threshold, they will not be. But to be exempt, again, you got to meet the duties test, but you got to pay the minimum salary threshold. So, the next couple of slides are, what can we do? You can review those at your leisure. I think the materials will be accessible to everybody. But basically, you need to sit down and kind of look and track the hours. If you've got somebody that you don't necessarily want to raise them up to the $35,000 threshold, look at whether they're really working overtime. Even though they're an exempt now, or they get their job done in 40 hours a week or less, you may not need to raise them above overtime. If you've got somebody that is regularly working overtime, how much overtime? Are they working enough overtime that between their regular rate and their overtime rate, they'd be above $35,308 a year? You may want to raise those employees, but ultimately the decision is up to you. But it could be a cost factor if you've got employees routinely working overtime that are going to be above that threshold, and it's going to be a cost factor.
Hey, Steve.
Yeah.
If this goes into effect, and I know this is all up for grabs at this point, would it be on a one-year look back? Because I don't know that you could instantly say we don't keep track of our exempt employees' time they work. So we'd have to start keeping track of it.
You may want to start trying to keep track of it now, because some form of a rule is coming out, and it would basically be for that year going forward. It wouldn't be looking at what happened the prior year. So if it goes into effect January 2020, then the overtime that they're going to be accruing is based from January 1 to December 31st of 2020. There's not going to be a look back as to what happened the prior year. It's the current year that you're assessing. So the reality of it is, the exact terms of the rule and the salary levels aren't final, and maybe won't go into effect January 2020, maybe it'll be later in 2020, but at some point this is going to come into effect, so you may want to start looking at what your exempt employees who are close to that level are doing in overtime. And I will add this, and it's missed by a lot of people. The Illinois Wage Payment and Collection Act and the Illinois Department of Labor actually requires employers in Illinois to track the time of their exempt employees as well. Now, there's very little penalty and repercussion if you don't, unless there's been a wage claim challenge and somebody actually tries to challenge whether they're truly exempt if they don't have the duties. then you don't have the data, then the presumptions are all against you as an employer. But to the extent that your exempt employees balk, and that's where I was going with this, if they say, well, I don't have to track my time, your cover is under the Illinois Department of Labor, through the Illinois Wage Payment and Collection Act regulations, you're supposed to be tracking. So you can always point to the government and say, they made me do it.
Thank you.
Yep. Now, the other thing to consider, and I always like to touch on this, is controlling unwanted overtime. In the Fair Labor Standards Act, the regulation, I've got it there, 785.11 says that work not requested but suffered or permitted is work time, and work time must be paid by the employer. Now, it's interesting words they use, not requested but suffered or permitted. It basically means if you know they're working the hours, you got to pay for it. Now, that doesn't mean they get carte blanche to do what they want on overtime or free reign to decide their schedules, because the act goes on and the regulations 2 sections later, section 13, says it's the duty of management to exercise its control to see that work is not performed if the employer doesn't want the work performed. And they go on to say that the mere promulgation of a rule not to work or to send it is not enough, you must enforce the rule. What does that mean in English? Well, what I'd say is look to this case, Ritchie versus St. Louis Jewish Light. St. Louis Jewish Light is a newspaper in the St. Louis area that caters to the Jewish community. And they had some cutbacks, and so they began to shuffle some duties among the employees who were cut, among the other existing or remaining employees. And one of them was a woman whose last name was Ritchie, and she was told, hey, now you're going to have to pick up these other 2 duties that we need you to perform. And oh, by the way, no overtime, get these additional duties done in 40 hours a week, figure out your schedule. She said, well, that's just not possible. I'm, swamped as it is, and for me to pick up additional duties, I'm going to have to put in overtime. The supervisor said, no, you're not allowed to work overtime. You do your job in the 40 hours a week, figure out how to get it done. Well, first pay period comes, she does the extra duties, and she records overtime. She says, I can't get it done. Well, the employer does what it's obligated to do under the Fair Labor Standards Act, pays the overtime, has another meeting with her and says, don't record overtime. Don't work, and not record, don't work overtime. You need to get this done in 40 hours a week, figure out how to make it happen. She does it again. She records overtime, they pay overtime, this time they reprimand her. She does it again. This time they fire her. She immediately brings a lawsuit against the St. Louis Jewish Light, alleging that they're interfering with her rights under the Fair Labor Standards Act and retaliating against her for exercising her rights. And the court said no. The employer has every right to control the work, and what you did amounts to insubordination. You were told not to work overtime. They had a rule not to work overtime, and you continue to work it. They don't have to suffer that. They did the right thing in paying you for what you work. They can tell you you're not allowed to work overtime. So the takeaway from that is, again, in the whole analysis of what rule is final and what you're going to do, have a policy on overtime, when it's authorized, how it's approved, and if they step out of line, they violate it, issue discipline. I wouldn't say necessarily fire them the first time, reprimand, suspension, but if the problem continues, you're entitled to enforce a rule. Now let's switch gears to Illinois and how the Illinois government is here to help you. I'm sure most of you probably heard it, there is a new minimum wage law in Illinois that was signed into law in February of this year. This had been tried a couple of times under the Rauner administration. He vetoed it even though it passed through the Illinois House and Senate every time. It's now been signed into law. It's going into effect, and it will take the minimum wage up to $15 an hour by 2025. It also provides now for the teen wage, which had previously been 50 cents less than the minimum wage. Now the teen wage will increase on its own up to $13 an hour. They also now specifically define teen. To be teen, you have to be under 18 and work less than 650 hours a year. So if you're under 18 but you're working 700 hours a year, you're under the other minimum wage, not the teen minimum wage. This is a chart in the materials I figured I'd throw in there. It just shows you sort of the benchmarks of when the increases are taking place. I would point out of note that next year in 2020, there's actually 2 increases. Every other year, the increase takes place on January 1. But next year, January 1st, the rate will go up to $9.25 an hour. And then on July 1st, we'll go up to $10 an hour. So you get hit doubly next year under the new minimum wage law. And there are, just to make sure you're all on board, there's increased penalties now for violations of the Minimum Wage Act. If you underpay somebody, pay them less than that, they can collect triple what they would otherwise have been due. So if in a pay period you short them $150, using that by example, and they have to sue to collect, they can collect $450, plus their court costs, plus their attorney's fees. Always a good thing when the attorneys get paid. And built-in statutory damages of 5% per month of the amount of the underpayment. So you're earning interest on the $450 that's unpaid every month, and it remains unpaid. And if the employer's conduct is found to be intentional, not a mistake, that they purposefully short-paid somebody and violated the act, there's an additional fine of $1,500 against the employer that's payable to the Illinois Department of Labor. The next act to talk about, and this is one that's probably the most significant because of its potential impact, and I don't know that it's gotten the press of a lot of the new laws in Illinois, but it's the employee expense reimbursement. Some people are calling it an act. It's really not a new law unto itself. It's a new section that was added to the Illinois Wage Payment and Collection Act, and so it'll be enforced through the Department of Labor, similar to that. Of course, the Illinois Wage Payment and Collection Act is the ability, it sets the rules and ground rules for how you pay your employees, how frequently you pay them, what's final compensation at the end of employment, and those things. And it provides a way for employees to make wage claims. And so now this has been added to the mix. And what the new section requires is that employers reimburse employees for necessary expenditures that they incurred in performing their job. And what's a necessary expenditure? It's defined in the Act, and I've got it here. It's a reasonable expenditure or loss required of the employee in the discharge of employment duties that inure to the primary benefit of the employer. So that sounds simple enough. So I'll just move on. The other thing to keep in mind, and I'll touch a little bit more on what that means, but there are some protections built in for the employer. The employer is not liable for a loss that's due to the employee's own negligence or carelessness. So if they break something or lose something, you don't have to reimburse them for that. Losses due to normal wear, if they wear out a piece of equipment. Losses due to theft, unless the theft is the employer's fault. So if you tell your workers are bringing tools to the job and you say, hey, just leave them here overnight, I'll lock up on the way out and you'll be fine. You don't have to carry them in to and from work, but you forget to lock up and the place gets burglarized and you lose the equipment, you're going to have to pay for that. It also says that the request for a reimbursement must be submitted within 30 days of incurring the expense. And if they miss that, then the obligation to reimburse is gone, although the employer can change that by written policy. And the fact that there is an ability to have a written policy is a unique feature among similar statutes in other states, but that's more unique to Illinois that they built this in. And so they also say that an employee is not entitled to reimbursement if the employer has a written policy and the employee fails to follow it. So you can set the terms and sort of guidelines, or if the employer didn't authorize it. So they didn't say you had to incur this expense, or incurring this loss or expense was a mandatory part of your job or your duties, or the expense exceeds the employer's guidelines in the written policy, so long as the employer's guidelines don't provide for no reimbursement or de minimis reimbursement, which means basically such little reimbursement as to effectively be nothing. And an example I'll give is where I think something like this goes. If you require safety boots for your employees, steel-toe boots for them to work, and the range of that could be 100, 200, 300, depending on the boot that the employee wants. The employer can set a guideline saying we will reimburse $100 for safety boots and set forth the process. So if the employee wants to buy the $300 pair of boots, they get $100. If they want to buy $100, they're going to get it all. But you have to set a reasonable amount for the reimbursement of the expense, and it has to be in a written policy. So what does all of this mean? Well, there's a lot of legalese and lawyer language and some pretty broad statements. There's no real clear guidance as of yet. The Department of Labor in Illinois hasn't issued regulations to further define or clarify the act. There's no cases because there's been no lawsuits or enforcement actions yet under the act. But I will say, for some guidance, the Illinois law was modeled primarily after the law in California that's been on the books for more than 20 years. And as another aside, you just generally don't want to copy California law on any topic, but we've done it here. But I will say the California law doesn't have the ability of the employer to set guidelines in a written policy, so that's a benefit here. But primarily, the California law has been used to require reimbursement for cell phone expenses and home internet access expenses. And that was the real sort of impetus behind the Illinois law going into effect. If you're requiring employees to have cell phones to communicate, even to have smartphones, I know some employers have smartphones that they load apps on, and that's how you log in and out of work, or log your time. Or supervisors have to be accessible after hours by phone. If you're requiring that sort of duty from them, then they're going to be entitled to a level of reimbursement. Now, it doesn't mean if their monthly plan is $50 to $60 a month, you've got to pay or reimburse all of that. It has to be a reasonable expense, commensurate with their employment use of it. So again, you can set the policy and the guidelines. The other things that's been in place for is licensure and training. But the interesting thing under the California law, if your license is required as a matter of law for you to do what you do, like I'm a lawyer, I have to be licensed, a member of the state bar. If I'm not, I can't practice law, I can be prosecuted for that. Since the state requires that I have a license to be a lawyer, anybody that employs me as a lawyer does not have to pay my licensure, although most employers actually do. Same with doctors and realtors, things like that. But if you're requiring a specific licensure or you're requiring a specific type of training, you're going to have to reimburse for that.
Is that the same with like the safety requirements? So if you're in a field that requires specific safety gear as a regulation, not a state or a company policy?
If you can expressly show that it is a regulation that it's required to be in that occupation, you can probably make the argument that's similar. That is frankly going to be one of the gray areas. I mean, in another gray area, and it's not even safety gear, but I've already had questions posed. What about nurses in skilled nursing facilities? Do you have to give them stethoscopes, blood pressure cuffs, each individual, or do you have to reimburse them for them to buy them? What I've talked to a couple of employers and advised as well, have a couple of stethoscopes available on the floor. And then you can say, we're not requiring them to incur the expense to buy their own. We're supplying them if they want to buy their own. Now, it's a little different with safety boots because you're not going to have one pair of boots for employees. But it's a trickier issue. My sense is, given the liberal nature of the Department of Labor, on safety equipment, you're probably going to be held to reimburse, even though there may be a safety regulation, an OSHA requirement, something like that, for personal safety equipment. I think that's a gray enough area that they're going to lean to favor the employee. But again, there's no clear guidelines on that yet. And so that's, the next slide is, how do you address this? You need to assess the workforce, what expenses you are requiring, what expenses are being incurred, how much of that is actually required for the duties, and make that analysis and set out a written policy, set out the guidelines. Because if you set out guidelines and provide for more than de minimis reimbursement, I think you're going to be covered, even if you're not reimbursing everything. The next helpful feature of Illinois law that's been new, there's been amendments to the Illinois Human Rights Act. And there's really only one amendment that's the most significant we'll get to. But quickly, and I don't know how many have had experience with the Illinois Human Rights Act or the Illinois Department of Human Rights that administers the act. But basically, if you have an employee who alleges they've been discriminated against because they're a member of a protected class, be it age, race, sex, disability status, something like that, if they're going to bring a charge of discrimination, they can't go to court first. They have to first file their claim with either the Department of Human Rights or the federal EEOC, and then that agency, whichever one, will go through an administrative investigative process, issue a report at the end, either saying that we find evidence to support the claim or no evidence, so they'll dismiss it. If they find evidence to support, the employee has a choice to have the agency itself prosecute the claim or go on their own to court to file a lawsuit. But they cannot go to court until they go through the agency process. Both agencies, the EEOC and the Department of Human Rights, have been plagued with inefficiencies and backlog. They're supposed to complete the process within a year. The last handful I've had to work on for employers, the department's frequently asking for extensions of time so they can complete their investigation. So they've amended the act to try to address some of the backlog. One of the things they did is they used to be 13 part-time commissioners. They've changed it now. They have 7 full-time commissioners that they think will be able to address the backlog. They've also now this one, I'm not exactly computing how this affects the backlog, but they've extended the period of time to file the claim. It used to be 180 days to file it from the alleged act of discrimination. Now it's 300. But the reality of it is, as a practical matter, it makes a little difference because the EEOC was always 300 days. So if you missed the Department of Human Rights, you could go to the EEOC. And when you file in Illinois with either the Department of Human Rights or the EEOC, they notify each other, and it's considered a dual charge. And they sort of piecemeal among themselves who's going to handle that. And sometimes the EEOC investigates, sometimes the Department of Human Rights. So really, I'm not sure that it makes a heck of a lot of difference on the extension of the deadline. The more important factor of addressing the backlog, I keep dropping on the keys here, is the ability to opt out. As I said a minute ago, before you could run to court and file your discrimination lawsuit, you had to go through the process. Now you can opt out. And basically within 10 days of filing your charge, now the Department of Human Rights has to send the employee a letter saying, you have the right to opt out. You don't have to suffer through our lengthy and unduly long process. If you want, you can go right to court. Once the employee receives that, they have 60 days to make their decision to opt out. They have to make it in writing within the 60-day period, and they send a notice back to the department saying, yeah, we want out. And when the department gets that, then within 10 days, they notify the employee, okay, now you have 90 days from today since you opted out to file your lawsuit. And they tell the employer, oh, they opted out, and they're going to go, they have the right to file a lawsuit in 90 days. So you can go not right to court, but a little more quickly to court if you want to as an employee. And there's not a lot the employer can do about it. In my opinion, the likely result is going to be more frivolous litigation. And not every charge of discrimination is frivolous by any means. But what I've found in practice is that when you go through the investigation process, either the EEOC or the Department of Human Rights will say, we find merit or we find no merit. And if they find no merit, the overwhelming majority of the times, no lawsuits ever filed. Now, I can't say that as an absolute rule. Some people are obstinate and will do it even after being told they don't have a claim. But I think if you're letting people opt out before there's an investigation and a report and some findings, you're just encouraging people to skip the process altogether. A couple more new rules we'll go over. There's been an amendment to the Nursing Mothers in the Workplace Act. This has, again, been around for quite a while. It used to provide for unpaid leave, at least one break a day, not leave, I should say break. Unpaid break, at least one a day, for a mother to express milk after she's given birth in the workplace. Now, she hasn't given birth in the workplace, she's expressing milk in the workplace. There is no statute on the other. They have now amended the Nursing Mothers in the Workplace Act to provide that the break has to be paid. So you can't make a deduction. The other thing is they can take as many breaks during the day as reasonably necessary. And I love when the government tells me what's reasonable and what's fair. So it's sort of opened up to multiple breaks, and they can take as many breaks as reasonably necessary that are all paid for up to 1 year after giving birth to the child. So the only way out of that as an employer is you have to show it's an undue hardship as defined under the Human Rights Act, and good luck with that. Because if you're having trouble sleeping, let me know. I'll send you the definition of undue hardship. It's convoluted, but basically you've got to show it's an outrageous expense or it severely so impacts the operations of your business that you just cannot let it stand, and I don't see how this is going to unduly be expensive or impact your operations. Another new law or new amendment is to the Equal Pay Act. The Equal Pay Act of 2003 in Illinois prohibited discrimination in the payment of wages based on sex. So you couldn't pay men more than women or women more than men solely based on their sex, if they were performing the same or substantially similar work. There are exceptions to that based on seniority, quality of the work, quantity of the work. So if you've got a 20-year female employee and a 2-year male employee, you can have differences in pay based upon the seniority. You could also have that based upon if the male or female is way more productive, if it's piecemeal work and they're generating more revenue or more product is being produced, but it cannot be based on a discriminatory factor. Well, that act's been amended, so now it's not just based on sex, but specifically also says that you cannot pay African American employees less than you pay non-African American employees on the basis of their race. It still has the qualifications of seniority, quality, quantity of work. The odd thing to me is why just African American employees, why not Hispanic, why not Asian? I don't understand why the carve out other than the cynic in me says the lobbying group. I think effectively with this amendment to the Equal Pay Act, it does make clear that you can't discriminate in pay based on race now too, because there is language that I've set out here that they also, in addition to identifying specifically African American employees, it says, or any factor other than race or discrimination under the Illinois Human Rights Act. Discrimination under the Human Rights Act is very broad and covers all races, age as well. So it's probably opened the door to be a little bit broader, but interestingly, it confines to one particular race on the amendment. Another new law, and it's a relatively new law itself, and it's new that it applies to employers, is the No Stalking, No Contact Order Act. Previously allowed, it's been around for a few years, allowed victims of stalking or the family members of victims of stalking to go to court and get a protective order, no contact, no stalking, that if violated could subject the offender to being arrested and prosecuted. The act was amended effective January 1 of this year to now allow an authorized agent of a workplace, school, or place of worship to apply for a no contact order. And the implication of that is if you've got a disgruntled former employee who's threatening managers or showing up, being a little irrational, you can certainly now, as an authorized agent of a workplace, go and get a no stalking, no contact order, so if they show up, they can be removed by the police. But you can also apply it if you've got an employee who has a spouse or significant other who's now stalking them, or just a crazed person, and you're worried about violence in the workplace or the impact of that. Now the employer itself can go out and get a court order banning it. So it's another arrow in the quiver in protecting workplace violence. And those are kind of the big key issues of new laws. I'll skip the slide again. Now I want to cover pending legislation that may impact you going forward. This is under the heading of how may the government help you in the future. And right now there's the Workplace Transparency Act that is working its way through the Illinois legislature. And this is really a carryover of the Me Too movement that got impetus last year. And there was some legislation last year applying to local government and state government employers that banned confidentiality agreements or confidential settlements of sexual harassment claims, required reporting of those claims, required local governments to implement a sexual harassment policy, which technically you should have done anyway as a private employer under the Illinois Human Rights Act already, but also requires annual training on sexual harassment. So this act is to bring a lot of those protections into the private sector. Kind of covered them here already. It's the banning confidentiality of sexual harassment or other discrimination claims and the settlement of those claims. Prohibiting a union representative from representing both the alleged victim of harassment or discrimination and the perpetrator in a disciplinary proceeding. That's happened on occasion. You get a union rep either way you are, and they send the same person, and they just, I guess, sit on one side of the table and then get up and sit on the other. But now the union can't get off on the cheap on that. And it does require now employers, all employers, to report the number of claims and settlements and court actions to the Department of Human Rights, and requires annual training. And I say requires, the expectancy is that this will pass. It hasn't passed yet, but the reality of it is the likelihood is that it's expected Governor Pritzker would sign this into law. Another amendment, and this one it's on the table and working its way through the legislature. It sort of flies in the face of the backlog that we talked about at the Department of Human Rights. But this is to change the definition of what's an employer under the Human Rights Act. Right now, to be an employer covered by the Act, you have to have at least 15 employees in Illinois. Now, there are carve-outs that have been made over the years. If you're accused of sexual harassment, disability discrimination, or pregnancy discrimination, you only need to have one employee. But for race, disability, age, religious discrimination, you have to have at least 15 employees. This amendment would change that definition. You have to have one employee, so effectively make every employer in the state of Illinois covered by the Human Rights Act, which certainly isn't going to alleviate a backlog. That's interesting. Fill in the blank, what law do you want? The next one, and this one is expected to pass, and actually this one made it through in prior years, over the last 2 years. This is requiring paid sick time. And it was twice passed in the Illinois legislature over the previous couple of years under the Rauner administration. It was vetoed. Well, it's back as well. And this time the expectation is that Governor Pritzker will sign it into law. What it requires is that every employer in Illinois provide a minimum of 40 hours of paid sick time per year to its employees. So sick time would now be mandatory if passed. They also define what you can use your paid sick time for. So your own illness or injury, of course, injury or illness to a family member, you can use your paid sick time. I love this one, child care for a child whose school has been closed by order of public official, which only a lawyer could say snow day in that way. Now, it doesn't necessarily mean that that's a bad thing, but they're expressly basically saying if your child's school is called off and you don't have other arrangements and you have to stay home, you can use paid sick time. The other is if the absence is caused because the employee is a victim of domestic violence or sexual assault, or they have a family member who's a victim of the same. And the last one is an interesting twist too, absence to visit a family member in prison or to attend a court hearing, whether civil or criminal, for themselves or a family member. So if you fall into one of those categories, you can use what you would be given up to 40 hours of sick time a year. The employer is free to expand on that and to give more sick time than they would otherwise get. And I just figured out by looking at my notes what slide was blanked out for some reason. So moving back to the blank slide, you'll just have to look at me and suffer through. There is a proposed amendment to the Equal Pay Act yet again, although this one isn't based upon any protected class. It's banning an employer's ability to ask any questions about prior salary or wage information of anybody that's being hired. So regardless of the protected class, somebody applies for a job, you cannot ask them, you cannot ask their prior employer what they made at their prior occupation or the prior job. Again, this was another law that was proposed and passed through the House and Senate in Illinois, but was vetoed by Rauner previously, and it's back and expected to be signed.
Hey Steve.
Yeah.
With the one that you just went by to increase sick time.
Yes.
I'm sure what they're expecting you to do is just toss in an extra week's worth of wage for that. Is there anything in the law that says you can't take PTO time, reduce that? So if you give them 3 weeks, you make it 2 weeks instead and give them a week's worth of that. And the other question I have is what's their definition of family? Because that's changed immensely.
Yeah, and there's various iterations under the Healthy Workplace Act. Let me go back to it. The notations there, SB 471 is Senate Bill 471, HB 2343 is House Bill. They're not the same. So there's tweaks and variations, and so it's hard to say. I'm confident something's going to get passed. I can't say the exact parameters of it at this point, but it does address, I mean, basically most of the definitions of family is going to be step family, step siblings, extended family. It's a pretty broad definition. And that's what's built into it now. And, you know, as far as use of PTO time, it's not entirely clear at this point. If you have PTO time and you expressly say that it provides a level of, it can be used for sick leave, my opinion, unless I see something in one of these final bills that says different, that PTO time is sufficient as it is, as long as it provides at least up to 40 hours for the employee to use. Now, you probably within your PTO policy don't have the ability to use it expressly to visit a family member in prison, or necessarily because you don't think of it for sexual assault or domestic violence. So you have to expand the definition of the eligibility to use it a little bit, but you won't necessarily have to implement a whole new policy if you've already got some level of sick time, and there's a number of employers that already have a sick leave policy out there. As long as they're at least meeting the minimum of 40 hours, I don't think you're going to be required anything different other than meeting these additional categories of eligibility to use it.
Thank you.
The last thing that I'll talk about today is the move under House Bill 2565 to prohibit all non-compete agreements. And this would be an amendment of the Illinois Freedom to Work Act, which was passed a couple of years ago. And under the Freedom to Work Act, it prohibited non-compete agreements for low-wage employees or low-wage workers, which the statute defined as making $13 an hour or less. You couldn't have a non-compete agreement. It all arose, interestingly enough, from a lawsuit because Jimmy John's made their freaky fast drivers and sandwich makers who were making 10 and 11 bucks an hour sign non-compete agreements. Because you know, if you wanted your Italian nightclub, but your worker went to Burger King, you're now going to go to Burger King and get the Bacon King. and try the Bacon King, it's worth it. Now I know that goes against all the wellness that we've talked about. But I'd take the Bacon King over the nightclub. In any event, back to the issue at hand, they want to expand that act to now say all covenants not to compete or void against public policy. It's not clear at this point what they do about agreements entered into before this would be passed into law, if it's passed into law. But it would make Illinois one of a handful of states that ban them. California is one. Again, I never recommend following California law. But there are a few other states as well, so it's just something to be aware of, and it's on the horizon.
Is that just across the board? Because before it was, as long as you gave some kind of compensation for the,
well, that's always been the standard, that you have to have consideration to support.
So it takes that completely
Takes
off the
it
table.
there no matter what. And the interesting, to me, the more interesting nuance is I think that this would just apply in the employment context. So you're right, you could have consideration for a non-compete agreement under the law today is if you don't pay them extra up front and you just basically say, coming to work for me is your compensation for the non-compete. Illinois courts have said you basically have to work for 2 years before the covenant becomes enforceable. So if you quit or you're fired in under 2 years, it's not enforceable anyway because there's not sufficient consideration, you didn't give up enough for it. If there's a payment up front, it's enforceable automatically. The nuance to me is what happens in the sale of a business. You sell your business, and as part of that, I'm buying, your widget business from you, and I don't want you to go open up down the street now that I just bought it all and got your goodwill and your customers and your product. So I get you to sign a non-compete for, you won't open up another widget business or something substantially similar for 5 years. Are they going to take it off the table for sale of business categories, non-compete, non-competition? I don't know that they're intending to go that broad, but the language right now that I've seen is pretty general, and so there's a question as to whether it would apply in that context and not just the employment context. So again, something to watch out for. Any other questions?